Now we are discussing an appointment of managing director. What is this section 196 of Companies Act 2013? Section 196 governs the appointment, reappointment, tenure, eligibility, approval process for managing director, whole-time director, manager. So this ensures the key managerial personnel are appointed in a transparent, regulated and time-bound manner. Does section 196 apply to private companies? Partially apply, yes. 196 applies to private companies. However, private companies enjoy specific exemption under section under MCA notification 5th June 2015. So partially exempted. Subsection 4, subsection 5 exempted. Members approval and central government approval exempted for private companies. Even subsection 5, ratification of acts done before members approval. So these two subsections do not apply to private companies. So is shareholder approval required for appointment of a whole-time director or managing director in a private company? So the answer is no. Shareholders, that is members approval, is not required for appointment, terms and conditions and remuneration. Only board approval is duly convened board meeting is mandatory for private companies. So is board approval compulsory even for private companies? Answer is yes. Board approval is mandatory. Even though members approval is exempted, that the appointment, remuneration, MD, whole-time director must be approved by the board of directors, properly recorded in the minutes, board minutes, and it shall be filed, DR12 filed with ROC. So what is the maximum tenure allowed under section 196? The answer is whole-time director or managing director or manager cannot be appointed more than 5 years at a time. Reappointment can be done only with the 1 year before expiry of the current term. So the rules applies to both private companies and public companies. These rules apply for both the companies. Can a company appoint both the managing director and manager at the same time? No. Answer is no. Are there any age restrictions under appointment under 196? Yes. Below 21 years, not eligible. 70 years, 70 or above, eligibility only with the special resolution. For all companies. For private companies, although general member approval is exempt, best practice is to record justification in the board minutes if age is above 70. Who is disqualified from being appointed as a MD, whole-time director under 196? A person cannot be appointed as a MD or whole-time director if he or she is an undischarged insolvent, suspended payment to creditors, has made any composition with the creditors, has been convicted and sentenced for more than 6 months. Any court cases and there the sentence is more than 6 months. And these disqualifications apply to all companies including private companies. Is central government approval required for private companies? Answer is no. Due to the exemption, section 196.4, 196.4, 196.5 both exempted. Section 196 links it with the section 197, remuneration limits. Answer is yes, but they operate independently. 196 governs with the appointment procedure, 197 governs the remuneration limits. A private company may be exempt from 197 limits if no default. If there is no default, then 197 exemption is there, but still required to comply with 196, wherein board approval, tenure, eligibility. This is mandatory. Is DR12 filing is required for MD, WTD appointment for private companies? Yes. There is no exemption for filing DR12 even for private companies. Can acts done by MD before approval be required in a private companies? See, section 196.5 does not apply to private companies, but there is no requirement of subsequent members' ratification. Act done after board approval are valid. What are the consequences of non-compliance with section 196? Non-compliance may lead to invalid appointment and ROC objections, disallowance of remuneration, qualification issues during secretarial or statutory audit as applicable. So what is the safest compliance approach for private companies? Pass clear board resolution, define terms, powers and remuneration, ensure 196.3 eligibility criteria, file DR12 within time, check 197 exemption conditions if any default is there, whether that 5th June 2015 exemption and applicable suppose if the company default in certain conditions. So please check that. This is what about section 196, appointment of managing director in private companies. Thank you.